Welcome back. My name is Bob Bianchi. I'll be taking it from 12 to 3. Breaking news. We have a note from the jury in the Kachinsky case. They are hung 9 to 3. Let's take a look at this. I think they're going to be coming back in the room. I know the defendant is inside of that courtroom. And again, I repeat, in this fascinating case, it is a hung jury at this point in time. I'm going to bring on immediately my friend, hashtag 4041, Gene Rossi. Gene, we were talking about this case yesterday, and I was saying to you, I find it hard to imagine it's going to be a guilty verdict. I think we're going to go into court. I'm sorry, Gene, I'll be back. We see the jury is filing in. Gene, this is typical. Usually the judge will give them what they call an Allen charge to say to them if they don't do violence to their judgment, go back and try to come to consensus. So we will be awaiting. My producers will let me know, Gene, when that courtroom is live with something that's relevant. But tell us, I mean, a tough case. What do you think the judge does? Does he give the Allen charge?
Oh, absolutely he will. And I assume it's 9 to 3 for conviction. I could be wrong on that. But he would give an Allen charge. In the Eastern District of Virginia, they have a Fourth Circuit case called a Sawyer charge, but it's a dynamite charge. Basically, go back in that room, try to resolve any differences if you can. Defense attorneys don't like the dynamite charge. Prosecutors love it because you want to get a resolution, especially if you think it's 9 to 3 for conviction.
Right. So, I mean, right now that favors the defense because, like we talk about all the time, Gene, the prosecutor's got to prove a case, obviously, beyond a reasonable doubt to 12 folks. So a hung jury favors the defense. Let's go into court. All right. Listen, they're making a record. Hey, Gene, I kind of wonder with this judge, like, he's been so genuflective to his court clerk, as most judges are, because the court clerks keep the trains running on schedule. But especially with a trial like this where the defendant is a municipal court judge, and this is basically an employment scenario, emanating out of an employment scenario with one of his workers, maybe they kind of told this judge, like, hey, I better watch my P's and Q's. I don't want to be sitting in the defendant's chair.
Absolutely. And I got to tell you, any judge across the land who acts in a weird or quirky way like Judge Kachinsky, they better watch out because you could be in the same hot seat.
Now, Gene, we talk all the time about the fact that you have to know the law in order to properly assess a case. And, of course, that's what lawyers do. I used to train my assistant prosecutors. I'm sure you trained many people at DOJ. I know you did, over 1,000 people, that you got to know what it is you have to prove. So I think it's worthy of telling our audience that stalking, which is, I mean, typically involves things that are a lot more egregious than what we see here, at least in my estimation. And basically, it says out there in Wisconsin, it causes the victim to suffer serious emotional distress. And I want to emphasize that that's a term of art. It doesn't mean just that you're upset, that it's uncomfortable. It's got to be serious emotional distress to the point where you're either, and I'm quoting, terrified, intimidated, threatened, harassed, tormented. These are the actual words in the statute, as well as a course of conduct is required. They also, and the defense lawyer is very quick to point this out in opening statements, that the defendant knew or should have known, and that there was no legitimate purpose for the encounters. And what came out during this trial was this judge basically saying, hey, I got a staff I got to run. What do you, I think it's a tough burden on a stalking case, which typically you see a lot more disturbing facts.
Well, you got 3 hurdles there, and you are absolutely right. Whenever I started an investigation or I handed off a case file to an attorney, new baby prosecutor, I said, before you go forward, print out the jury instructions for the proposed charge, print out a few cases from the Fourth Circuit, whatever state jurisdiction, and read that before you even investigate. And here I see 3 hurdles. You use that reasonableness test. Did he reasonably know what he was doing in terms of harassment? 2, you have this high hurdle of basically, are you torturing and tormenting her emotionally? And then, was the interaction part of the duties? Those are 3 tough hurdles. And I was just watching the testimony of Mandy Bartelt. At the beginning, I got to tell you, there were a couple vignettes that she brought up, and I'm thinking, okay, he's quirky, he's a little weird, but is this really stalking?
Yeah, and of course, you know, earlier they had a harassment charge against him, which they dropped, they said, for tactical reasons, which carries a lot less in terms of the stalking charge. I mean, the stalking charge is meant to be a serious charge. It carries up to over 3 years in state prison if you're convicted. And again, like, you know, what you see coming out in this case, and it was interesting because it came out from the prosecution, are these emails where he's saying, we need to normalize relationships. In other words, I was kind of putting myself in his shoes. I was just trying to do that and saying, I'm the judge, she works for me, I have to make sure things are operating correctly. So there's going to be interaction between them. At first, they're personal friends and they're sending stuff back and forth to one another. All of a sudden, she doesn't want any quote-unquote non-professional communications, whatever that means. And I guess in certain points he's saying, hey, we need to be able to get along. We need a truce. I'm just giving you the side that the defense argued in this case. And as the defense lawyer said last point, this is just two people interpreting the same set of facts differently. Yep. And that's not, you know, proof beyond a reasonable doubt in my mind.
Well, I read the opening. I didn't watch the opening of the defense attorney, but he had to comment that the facts are not in dispute. What is in dispute is two people are looking at the same situation. And I think he gathered a lot of credibility when he did that. Now, at the end of the day, it could be 9, could be 10-2 for guilt, but we got 2 or 3 jurors that aren't buying it. It could be one of those 3 hurdles that I just rattled off, that this is a civil harassment suit. Mm-hmm. But does it rise to a level of a criminal prosecution? And you got to know that subconsciously the jurors are saying, this judge could go to jail.
Yeah,
it's a felony.
Gene, I think that's a great point. The prosecutorial discretion, I said to one of the people here at the Law&Crime Network before we got on here, what's going on behind the scenes with this? Like, why did the prosecution pick this case? There are lots of other legal remedies that could be chosen, but they decide to go to a case where they have to prove it beyond a reasonable doubt to 12 people and have this guy facing jail time. I mean, I get that people are agitated because apparently he did not want to follow the HR directives, and he was bristled by that. But is that a crime?
Exactly. And I got to go back. I may have mentioned this on an earlier show. I indicted a state prosecutor for witness tampering and obstruction. And I had an acquittal. And at trial, the jury felt sorry for the defendant because how could it possibly be that a prosecutor broke the law? The jury subconsciously may be saying that, at least 2 or 3 of them, in the jury room.
Well, we got a lot to do to break this down, Gene, because I told you yesterday not to look at certain portions of this trial because I think we were on the phone, and I said to you, your head's going to explode. So I wanted to wait to get your visceral reaction when we're right here, because I think there's another reason why the jurors may be a little confused in this case, and it's a really important one, and it comes down to trial tactics. We're going to take a break. Please stay with us. I'm going to be back with the great Gene Rossi on the other end. It's my shift. Bob Bianchi here from 12 to 3, and we already have breaking news in the Kachinsky trial, one that we've been watching across the nation. Man, it's an odd case. The jury's been deliberating. They came back. They said they're hung 9-3. We don't know if that's 9 guilty or not guilty, but nevertheless, they can't come to proof beyond a reasonable doubt with all 12 jurors. The judge brought the jury in the courtroom, as they normally do, gave them what we call in the business an Allen charge, which essentially says, try to go back in there and come up with some sort of compromise. Now, our great legal eyes, Kathy Russin in particular, at the Law&Crime Network, we got a whole staff of people that are checking things out, advises us that when the judge read that charge to the jury, they didn't look all too happy about having to go back in and deliberate. So we will come with you with any breaking news. But I got my man, Gene Rossi, 4041 here, and we've been talking about this case. We can't wait to break it down, especially the opening statements. As you know, me and Gene have taught a lot of lawyers, especially prosecutors, how to try cases. And there can be, in my opinion, I believe Gene feels the same way, no more important part of a case for a prosecutor especially than to lay out the evidence when you ask 12 folks to push a button on a guy, convict him with the potential of jail time. Let's take a look at this prosecutor's opening statement. I asked Gene not to look at it over the weekend because I have a funny feeling when he sees it now, he's not going to be too happy. Okay, Gene, Just so you know, that was essentially the entire opening statement of the prosecutor. I forget the exact timing, but it was like 5 minutes, and that's it. Now, there is no specific time that you can open, but I've been doing this for 30 years, and I have never seen so short an opening statement, especially, and I know this is the one that got you. I'm not going to talk about the specifics. I'm going to leave that to the witnesses. And this is what I think the evidence will show, as opposed to this is what the evidence will show. And the reason that's important is that this is your opportunity to tell them about the emails that are coming out, about the various things that happen, what the witnesses will say, so that the jury can put it into context, and that you don't let a good defense lawyer create a narrative after that where they do give specifics in favor of their client. Your thoughts?
Yes, what this was a prologue opening. And what I mean by that, it was very general. I'm going to get to our concerns that we have, but in terms of demeanor and approach and tone and looking at the jury, she did a very good job. And there were a couple of good points that I really liked, going over the elements and other things. But here's my major complaint about Amanda, and I think she has a terrific style, but this is something that I don't like. If you're going to have a case like this is a high-profile case, I would have spent 15 minutes, maybe 20 minutes, and I would have given them vignettes, examples, documents to show how he made her life miserable.
Yes.
She used that prologue sentence, he made her life miserable. How did he make her miserable? Mm-hmm. And she said twice, I think it was twice, I'm going to leave it to the witnesses and the exhibits. No, yeah. You in your opening are going to tell them what the exhibits and the witnesses are going to say. You don't have to go through every exhibit or every witness.
Gene,
but yeah.
I'm sorry, but you want to get out as many times as you can all of the bad guy evidence that you've got. You have an opportunity in opening. You lose it there. But more importantly, Gene, when I was listening over the weekend to her testimony, and I was listening to that, this all started because of a Facebook post about her taking a vacation, him calling it a second honeymoon because they had been corresponding on Facebook before. And that's what initiated it. And then a couple of 2 or 3 other things that were presented, which, by the way, were out of context. I was confused. I was sitting there saying, how are the jurors making sense of this? Well, I don't have an opening statement to plug it in so that I understand the timeline of all this. And it sounded in the beginning very petty, and minds are being formed at that point in time in light of the fact that we never had an opening statement to tell us some of the good stuff that came in way later in the victim's testimony.
And here's another drawback. In the opening, I tried to be precise if I was quoting a witness. But I would summarize, I'd say, essentially, this witness is going to say A, B, and C. Mm-hmm. And she did not bring out to the jury what I call the ESPN highlights of Mandy, the emails, the other witnesses, the warnings. I would have brought that out, and that's my major criticism. But she did have a good style, and she went through the elements.
Gene, I agree with you. She's got a nice cadence in the courtroom. She may be a little young. I don't know how many trials she tried. I don't mean to say that she's a horrible lawyer. I'm just saying that prosecutors lose that opportunity, and that's a hole that the defense can drive through, because maybe this is just 2 people seeing things a little differently. Let's listen to what the defense attorney opened up to with regard to far more specifics than the prosecutor gave, which usually is the other way around. Okay, welcome back. Okay, we got a short period of time here, Gene. Boy, he's getting a lot of character evidence in this opening statement. He's really playing to the heartstrings of the jury. Cancer, he's sick, 5 years to live. He's his wife and how they do charity events. A well-known lawyer for 30 years. He's quirky. He's just Len. He would meow and whistle and salute flags. This is like who the guy is, and he's basically known as being, he uses the word endearing. Later in the opening statement, the defense lawyer says these are just 2 people having a conflict with one another, perceiving things differently. Boy, he got away with a lot, don't you think?
Absolutely, and he fronted a lot of the things that are going to come out with the witnesses. And I love when a defense attorney fronts the bad stuff And the odd and quirky is definitely bad. There are some weird things that he did, but he got in that when he passes the American flag, he stops and salutes. So you get all that patriotism stuff. And then the other thing, you get out the illness. And looking at this trial from afar here, I think that illness may have contributed to the hung jury, because when somebody goes through a death-defying experience like cancer, people kind of give them a break. And, with 5 years to live, it's probably more if he's, survived the treatment. I think that really helps him in the beginning of this trial.
Right.
I thought he did a good job. My one pet peeve, you ready for my pet peeve? I hate people that hold pens. I hate it. I really do. That's my pet peeve.
Well, I'm sad that you said that. Nevertheless, Gene Rossi, I think
you're the exception.
Yeah. I think that the point here, though, is that stalking has to be under the law that the judge reads to the jury a little bit more than quirky, odd, or behavior that you may find unsettling. And it's got to be a reasonable, if you will, provocation to a point where a reasonable person would suffer serious emotional harm to the point they're terrified, intimidated, threatened, harassed. In other words, they're tormented. They can't be on eggshells. Just such as you can have in a bad work relationship is not the standard. And that he knew this, almost like it was his purpose to do this. And what the evidence came out, in addition to what the lawyer said in his opening statement, Gene, is that Lenny was the kind of guy who was just trying to make the work relationship better when things went off the rails. He was just trying to have a good working relationship, and that came out loud and clear during. He may not agree with the way he went about it, and he did do some odd things. But listen, Gene, I'm sorry I can't get an answer to that because we got so much going on. We're going to go to break, and we'll be back on the other end. Okay, welcome back. So, Gene, in that second clip, we hear her then talk after the honeymoon Facebook post that he wanted to take pics in the courtroom, kind of like this is not an unusual thing. You take pictures with your staff and so on and so forth. Again, remember, he's a judge and she is his subordinate, that she declined to do that, that she put a recipe for, of all things, a muffin on Facebook, and apparently he went out and made these muffins and said, don't bring your lunch. I'm going to bring you a muffin. And she said, please don't bring me a muffin. I'll get my own lunch. Okay, so, Gene, I want to go back to what I was saying to you before about the importance of opening statements. When I was listening to this, based upon the lack of data given to me by the prosecutor in their 5 or so minute opening statement, I was kind of like, wow, I was expecting to hear like some sexual stuff, some, creepy, weird, odd, maybe odd, but we're talking about Facebook posts about a honeymoon, pictures in a courtroom, which are not really offensive and done all the time. People had a relationship before, a personal relationship, and a muffin problem. What do you think?
Here's the thing, Bob, it goes back to what you said in the beginning. Always look at the elements before you decide to charge a case. And does this look like a witness who's tormented, who's tortured, who's in an environment that's just uncontrollably painful? It's not there yet. Is it odd? Is it quirky, what the defense attorney said in opening? Is it eccentric? Yes. He follows her Facebook. He saw the muffin recipe. That's quirky. Mm-hmm. He wants to have photos with her in the courtroom, which it could be a legitimate reason. His daughter wanted that. Yeah. It doesn't grab me right now. There's nothing that's outrageous.
Right, and that's where we go back to the point that, and she's saying, and I feel bad for her, I'm jumping back and forth. You should not have to jump back and forth. The prosecutor should be laying a timeline out and the evidence. We got a lot going on. Going to break. We'll be right back. Stay tuned. I told you guys to strap in. We got a lot going on here. Our producer, Olivia, Gene Rossi, we've been on a wild roller coaster this last hour, having some fun, breaking down a lot of stuff going on, and we got a lot more to go. But listen, guys, as you know, one of my favorite parts of the Law and Crime Network is talking about top crimes. Usually we get some funny stuff there, but we got some pretty serious stuff, especially one of the cases I'm going to come back with my boy, #4041, Gene Rossi on the other end. Let's do top crimes.
Here are today's top crime stories trending on lawandcrime.com and across the country. 3 employees at a Sonic drive-in restaurant in Texas are under arrest after an ecstasy pill was found in a kid's meal. The employees, 30-year-old Tanisha Dancer, 35-year-old Jonathan Roberson, and 22-year-old Jose Molina, were arrested after the pill was found in a 4-year-old boy's Sonic kids meal. The child's parents called the police, and the 3 employees were searched and arrested after Dancer was found with 3 ecstasy pills in her pocket. The trio faces multiple charges and might face additional charges pending an investigation. A woman in Alabama is facing charges after her 6-month-old son was found dead in a motel room freezer. 36-year-old Amanda Gail Oakes reportedly left her son, Curtis James Oakes, in a freezer after he allegedly died in the care of her boyfriend, 28-year-old Carlton James Mathis. Authorities in Georgia had a warrant for Mathis's arrest on burglary and parole violation charges at the time the couple and infant fled to Alabama. Oakes now faces charges of manslaughter and abuse of the corpse. Authorities in North Carolina have arrested and charged a suspect in the killing of 13-year-old Hania Noelia Aguilar. 34-year-old Michael Ray McLellan is accused of kidnapping, raping, and murdering Aguilar, who disappeared on November 5th when she was reportedly forced into an SUV by a suspect outside her home in Lumberton. Aguilar's body was discovered 10 miles south of her home on November 27th. McLellan now faces charges of first-degree murder, rape, and 8 other felony charges. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Well, welcome back. That's Top Crimes. Gene Rossi, I got to ask you, I mean, that McClellan case, that last one, 13-year-old girl, FBI did a great job, bringing it down. I think it came down to forensic evidence, as I understand it, from the arrest. But, I've been doing a lot on Bianchi Law Talk, which is like a YouTube channel that I actually have with some informal hits I do. I was just doing one last night about how do we protect ourselves? How do we protect our teenagers from such random acts of violence, of pushing a girl in a van and just taking off without being a paranoid society? Gene, do you have any insights?
Well, I have 3 kids of my own, and I still have a teenager, 17, and I'm looking at the video now. It just scares the heck out of me. All I can say is this, keep your cars close to your house. It seems like this SUV was somewhat of a distance from the mobile home, and that's all you can do. You can't control them at 24/7. You could just give them advice to always be aware of your surroundings. Always be aware of your surroundings.
Yeah, Gene, just like the cops say, situational awareness and head on a swivel. And coming to walk here to the Law and Crime Network from the train station, I'd say 70%, it just drives me crazy, of people are walking around looking at their cell phones, walking into people. And you know what? And that's how people become victimized. Gene Rossi, you always got some great advice there. Listen, I just wanted to just real briefly, in the Kachinsky case, Kathy Russin was good enough to give us a little bit of an update. We talked about the Allen charge, so you understand what this is. The Allen charge essentially tells the jury when they say they're hung, and we know it's 9-3. We don't know which side, 9 guilty, not guilty, but nevertheless it's not 12. And they basically say, so our viewers understand this, that you should go back in, and I'm paraphrasing here, with the idea of an open mind and try to resolve disputed facts if you have them. And you may not agree on anything, but try to come to an honest and sincere attempt to arrive at a verdict. You should not be obstinate. You should be open-minded. You should listen to the arguments of others, talk matters over freely and fairly, and make an honest effort to come to a conclusion of all the issues presented and to you. And I think, thank you, Kathy, for that, because it really tells you what a real-life jury, what instruction a judge gives, and they go back in there. And like Kathy Russin told us, when the judge gave them that charge to go back in, they didn't look happy. So listen, we're doing a replay of some of this stuff. I think it's a fascinating case on lots of levels. We've done a number of pieces on the victim's testimony, Ms. Mandy Bartlett. Let's go back in there and listen to some more of the evidence that she claims justifies the stalking charge and serious emotional harm as a result of the municipal court judge she worked for's conduct. All right, Gene Rossi, so what Ms. Bartelt is saying, in addition to the other stuff, is that he would jog into the office. He would stop by a couple times when there weren't court nights. But let's not forget, He is her superior. It's a shared office of which he has office space in that office. And he would watch me. Part of his job, they will explain, is to give her performance evaluations. He would have to start emailing her, telling him he was stopping by, sometimes for 5 minutes, sometimes for 45 minutes. We talked about staring, but the prosecutor never described for us, because that is a very subjective thing, and it's hard to describe, but you should describe it. And he would tap a notepad and make cat noises and a meow with his mouth. And when she was telling the story, and I'm not coming down on her. She's a witness testifying, and I believe truthfully. She's actually smiling. You certainly don't see at this stage. There will be later, but at this stage, you don't see anything where I think the jury's going to be like, what are we doing here?
Well, I just mildly disagree with you. It's a little bit higher on the elements chart than this Facebook thing about the second honeymoon. Mm-hmm. We're getting closer. I agree with you. Her smiling, it could be out of nerves, but I got to tell you this, Bob. That is really creepy that you're staring at somebody from behind for 45 minutes and you're making cat sounds.
Well, Gene,
yeah.
Apparently this is something he routinely does. And like the defense lawyer said, he's got cats, and this is Lenny being Lenny. He meows to people. He meows, he's a meower. I'm not saying I get it. It could be creepy unless you know the guy. And I'm not saying it's not an employment problem. I'm just wondering, at least at this point, when I was going through this testimony, I'm like, why are we in criminal court with the potential of state prison time for 3 years on this? But again, there's more to come.
But Bob, I do want to say, I'm assuming it's 9-3 for conviction. There are probably 3 jurors that agree with your analysis. Is this inappropriate? Is this civil harassment? Is this something that should be the subject of a judicial misconduct hearing? Absolutely. But is it stalking under the criminal code? That's what's probably going on in that jury room.
Yeah, and I'm not suggesting, again, that this woman is doing anything that's improper. She's just a witness in a case, a victim, albeit. But again, I'm getting to the very narrow point, Gene, that I would have wished if I were a juror, I would know how this fit into the overall picture of all of the facts, and that would have come through the opening statement. I'm going to keep getting back to that. With the puzzle pieces, you're leaving me to guess as a juror, in my opinion. Let's listen to some more of her testimony. All right, defendant Len Kachinsky is on trial. His jury is out right now, deliberating after coming back saying that they were hung. Gene, we've listened to a number of things that she said were problematic, and then we get these 3 emails, June 16th, June 22nd, and I believe the other one was sometime in July. One email is where he's basically saying to her, this is S3 for in evidence, was indicating that you're better than my old clerk. It's not sexual in any way or whatever. You're better prepared. You have me able to do a better job in court because you're prepared. S4, I'm in a good mood and not influenced by steroids. Let's get a beer. Let's talk about this. You can record the conversation. You can have Doug, who's an intermediary, but we need to have respect and common sense with regard to how we approach one another in the workplace. And then S9 for in evidence is an email, rather a letter to the mother that he sent, indicating that she's very good, Mrs. Bartelt, at what she does, but that he wishes to have normalcy. And then there's that comment that men hate the silent treatment. So overarching, Gene, is this rising to the level of stalking? And let's keep in mind, the reason she's agitated about this, and I get it, I understand it, is that apparently Human Resources and others told him only have professional conversations. But what seems to me is the irresistible force is meeting the immovable object. He believes that positive relationships and normalcy and communication is part of the professional relationship. Thoughts?
The attorney said at his opening that the facts are not in dispute. The emails, the letters, all the comments, they're not disputing any of that. It's what is his interpretation. And the thing you kind of touched on it, what doesn't really put it over that hurdle yet, it may have done it for 9 people, is there's no sex. He's not saying anything inappropriate physically. He's not trying to have a relationship with her physically. He's not telling crude jokes. That really, if they had an email that had that kind of language in it, it would have been a unanimous verdict in an hour. But the jury is trying to put themselves in the mind of that judge, at least 3 of them, that, okay, this is my sole clerk. We have the same office, literally. We're in the same room. I have to have some conversations with her outside the office about business. And they could make the argument that last email was to serve that purpose because he didn't care if Doug was there. He didn't care if it was recorded. That goes to his state of mind.
Right. Excellent points, Jean, as always. Let's listen to some more of her fascinating testimony and see, Jean, because I can tell you, having watched this, it may start to change a little bit. Let's take a look. Bodily fluids on envelopes, emails talking about normalization of relationships. I never quite got that tie-in, and I was kind of surprised this was, I don't know if they were having a forensic person come in there. Nevertheless, let's go back to these emails where he's saying he wants normalization. One in particular struck me. My blood pressure is up again. Enough is enough. And basically what she's saying is that this is in violation of the quote-unquote agreement that they had with the town as to how they were supposed to be interacting with one another. And while that may violate the town's rules and regulations, it seems to me this judge is like, we need to have a normalized relationship, and I don't care what the town says. I'm your boss. What do you think?
Well, he's skirting not the law, but he's skirting the authorities and their recommendation as to how to resolve their relationship. I got to tell you, Bob, he definitely crossed the charging element Rubicon when he did that whole stand around her and knocked her family photos down and said, "Are you afraid of me?" And wow, did he cross the Rubicon on the bodily fluids on an envelope. Oh, my God.
Yeah, but Gene, I don't know whether I wrote in my little notes here as I was going through this testimony when that comment, which I was going to get to about, are you afraid of me now? I wrote literally, defendant crosses the line. And that thing with the envelope, if in fact it's proven to be blood, if in fact it was meant to have some sort of message, defendant crosses the line. I get all that. But Gene, let's talk to our audience about the difference between stalking. Some have said that this is more of a harassment case, which in fact he was charged with. It's a lesser offense. Their communication or communications in the course of conduct of repeatedly committed acts with the intention to harass another person for no legitimate purpose. The stalking charge is an upgraded offense. Gene, some have said, I'm not saying I'm saying it, I'm asking you. Does bringing this kind of case with these things that are uncomfortable and things that people are upset about, and I get it, are we crossing a line for real serious stalking cases that me and you have both seen in our careers?
This is not a typical one, and I think what you're focusing on rightly is legitimate. Were his communications to her, in his mind, legitimate? Were they trying to improve their professional relationship? Even though he was ignoring the directive, even though he's odd, eccentric, and quirky, in his mind, his mens rea, was that a legitimate approach to improving one of the closest professional relationships you'll find between a judge and a clerk? You are absolutely right. This is not the cookie-cutter stalking case where somebody's, hanging outside the house and with binoculars and then threatening at appropriate times. This is a unique situation. You're right. You're absolutely right. But those two instances, especially the envelope and the photos, I think he's crossing the Rubicon and coming close. And that's why 9 people are saying yes, I think.
Now I'm uncomfortable having my pen in my hand when I talk to you. But
no, you can use your pen because you're using it.
Gene,
you are using it.
Let's not forget, it's about the law. And the law also says for stalking, not necessarily for harassment, but for stalking, that the defendant knew or should have known that it would cause substantial emotional distress, and that is terrified, intimidated, threatened, harassed, or tormented. And the very fact that he's putting these things in these emails or whatever could be a defense to him to say if he thought that he was doing those things, he wouldn't have put those things. It's not a question necessarily she has to feel it. That's number one. And he has to know or should know he's causing it. That is a potential defense that all this stuff is going into the emails, with the exception, of course, of the conduct of leaning over. Let's listen to leaning over her desk and saying, "Are you afraid of me?" That's problematic for him. Let's listen to some more of her testimony. Okay, so Gene, that's Ms. Bartelt, and again, the way the prosecutor laid this out is starting with the Facebook post that was offensive to her, then moving into some office-related things, then some emails that were marked as exhibits that she said violated this agreement that he had with HR, although in those emails it seems clear that he believes that they should have at least a rapport, that his blood pressure's going up, that this is ridiculous. Now, he is a judge. He is the boss. And so he's basically writing those things. Then we had the physical contact where he leans over the desk and definitely may go over the line by whispering, certainly not a good thing, are you afraid of me? Blood on an envelope, whether or not they established it was blood or not, I don't know. And now a TRO, him then saying, I still intend on following the procedures, and then him putting on her desk sexual harassment policies. Again, Gene, I get back to, is this just a bad employment relationship where he's agitated at the fact that he's being told what to do with his employee, or is it rising to the level beyond harassment and into stalking where he could go to jail for 3.5 years?
Bingo, it is stalking. I think it's like a thermometer. He's hit that threshold. I think we now have it. I want to go back to the opening, Bob. We kind of were hard on the prosecutor, but there are 3 events I would have mentioned in the opening. At least one of them would be she got a lawyer. They had a hearing. They got a restraining order. And after the restraining order, he basically said, F you to the whole world. Mm-hmm. I would have mentioned a couple of those incidences. Wow, I got to tell you, to me it's now stalking because he is intentionally trying to hurt her and humiliate her and embarrass her, and that is part of the definition of stalking.
Well, Gene Rossi, again, I think we're saying the same thing, and it is a lesson to trial lawyers who come to this network or law students that it is imperative as the prosecutor that you lay out your whopper evidence from the beginning so the jury in their mind knows exactly how this all fits in and doesn't have to figure it out as you go along. Hey, guys, it's great being here with Gene Rossi, Law&Crime Network. We'll be right back on the other end of this break. Stay tuned. Okay, Gene, he's the village judge, not the village couch potato. I love a pithy line. So, all right, I'll just leave it to you. What's your initial impression?
Well, you know what? My initial impression is a net positive. He seems like a judge who is odd, quirky, and eccentric. He's got a sense of humor, and he doesn't come across as a deranged stalker. So that's all good. But we haven't gotten to cross-examination yet.
Yeah, and I don't disagree with you. I mean, and when you're looking at the overall part of the case, and again, this is not to blame the victim at all. She's not the one who brings cases. The prosecutor does. He right now, at least, strikes me as the kind of guy that you can understand. He's quirky, but he wants to have a good working relationship on a personal level. It was something he just could not swallow, that they were telling him he could speak nothing other than what's going on in that courtroom.
Right. And the other thing is, it goes back to the opening. The opening, the defense attorney talked about his illness. You know, I went through a cancer, high dose, and, you know, it kind of tugs at my heartstrings when anybody has to go through any of that trauma. So he got that out, humanized him. I did want to make a comment. Did you look at the presiding judge at the trial? You got a judge in the witness box and then a judge overseeing the trial. It was kind of a surreal moment for me.
Yeah. So let me ask you, when you're talking about the PIC line, that's the line, you got an infection, he's got all these problems. Are we talking, or can you explain to the jury, in a case that's kind of marginal, where a jury knows a guy could go to jail and he's otherwise lived a very, very good career by all estimations, there's a lot of support, community support, as an elected official. How about jury nullification? I'm just saying.
Oh, Bob, I'll guarantee you those 3 jurors, and we haven't gotten a note back. It's been about an hour and a half.
I know. Gee, I don't know. I'd like to know. Maybe Kathy Russian could find out for us. What is their lunch schedule? Because I think that many things revolve around the stomach with jurors. Let's go listen to a little bit more of the defendant's testimony to see if he continues to help himself out. Okay, so that's a defendant. He is speaking. Kachinsky is speaking in his defense in this case. Gene, so far, the guy's hanging in there, and very deftly, in my opinion, and I don't know whether the court had ruled on this previously or the prosecutor just didn't do anything about it. I just don't know. I'm interested in your opinion. Brings out that her previous employment was a problem and that she was having a terrible time there, and that the supervisors were screaming at her. I thought that this happy place and let's have fun all comes from Mandy as she transitions into a job with him. Do you think that they're trying to bring out there? She's a problem before, she's a problem now.
Right. And I think it's relevant. You know why, Bob? Because it goes to everything goes to his intent. And if he knows about her background and that she had a bad, toxic relationship with her former employer, that is even more reason for him to try to make where they work, in that room where they share, a better place. So I think it would be relevant. You know what? I got to say this about his demeanor. He is the most relaxed defendant I have seen on this show. We beat up on him so much, I'm afraid to do it again. Jason Van Dyke looked guilty when he testified. This guy looks very relaxed. He's comfortable in his own skin. It could be total baloney, I don't know, but on TV, he looks like, I'm cool, calm, and collected, and I didn't do anything wrong. That's the impression I get from him.
Yeah, and I know you're going to get heat for this, but there's something like the guy opened up to the defense lawyer, something quirky and yet intriguing about the guy. It doesn't come off as like a real bad guy, which is what he said most of the people in the community will say. Hey, Gene, great you being here. We're going to do more analysis, but we got to take a break. We'll be back with more of his testimony. I think it'll be fascinating. Gene Rossi, you know, when things like this happen to guys like me and you, sad to say, it's like Christmas early to get a verdict like this. But I said it all along. I mean, no disrespect to the victim in this case. I just didn't see how the state was going to prove this to 12 people beyond a reasonable doubt. And obviously, when they came back 9-3, in my opinion, they were 9 not guilties and 3 guilties. And finally, they did what the judge said. If it's not doing violence to your judgment, come to a conclusion. This was a tough case by the prosecution. In fact, I'll go one step further. I don't know why they even brought it. To me, it stinks of politics.
You may be right about the politics, but it goes back. The judge really did himself a huge favor. When he testified, he was relaxed. He was comfortable in his own skin. He gave the jury something to hang on all those red flags and loud gongs that the prosecution thought would prove stalking. He did a great job for himself.
Yeah, you know, I agree with you. He did, from what we saw. And we'll see a couple more clips because I think that was ultimately the most important thing here. But, you know, that's a really tough choice for him to make because the state's case, in my opinion, when you have laws that are there, stalking laws that require a lot of proof as to what his intent was as opposed to just how she felt, you know, you could say to the client, God, I think that we can make an argument and at least hang this jury. Do you really want to take the chance? And like you said before, Gene, we've seen some of the defendants who just completely blow up on the witness stand, as you mentioned, a la Jason Van Dyke.
Yes. And you know what? I just thought of something. In the judge's testimony, after they got that restraining order, didn't he say that Mandy came into the courtroom after the order, came into the courtroom and said kind of with a smile, how you doing, Judge? You know, if the jury believed that that actually happened, that kind of makes Mandy look a little I don't know, a little less sympathetic.
Well, it gets down to, I think, ultimately a jury. They got a tough law, in my opinion. You got to prove a lot as prosecutor, but they want to see, is this really somebody being victimized? Is this somebody that we want to push the button on and potentially send them to jail? I don't care what anybody tells me. That's in the back of the mind of every juror. And you were referencing the fact that after the restraining order was received, that she then shows up there when he's about to do a wedding and basically says to him, hey, Judge, how you doing, or whatever. And he's concerned he's going to wind up in a TRO trap and wonders. I guess it bespeaks the question whether it was stated by the lawyers or not. If you're in fear, if you feel like you need an order of protection by the court, why would you do that? Sorry.
Exactly, absolutely. And he really did himself a big favor by testifying, and I think that sealed it. If he hadn't testified, Bob, I think it could have been closer towards conviction than acquittal, if not conviction, if he had not testified.
I've been thinking throughout this case, Gene, and I, again, respectfully, reasonable minds can differ. I did not think they would get 12 to say guilty based on these facts. There's too much, as we talked before, jury nullification. The guy's sick. It's in a bad employment situation. He's a superior officer. What's work-related and not work-related? He's got emails, my blood pressure's going up, we need to come to a resolution of this. There's really no sexuality piece to this. There's nothing there. It's like you said, like binoculars and following a person around or cyber stalking. There's a little cyber, stalking. He did some things that were creepy, there's no doubt about it, but I just don't think it's enough to prove to 12 people beyond a reasonable doubt where they're going to convict the guy who's an elected judge.
Right. And is he now off the bench now, Bob? Is he off the bench?
I think he was at least, I'm not sure, we'll have the Law&Crime folks answer. I think he's at least suspended, as a result of this. And I see now in the courtroom the prosecutor is standing up, and I think the jury is there probably in the right-hand corner, and they're going to be excused. Gene, just to let the folks know, we have been fascinated by some trials where, death penalty cases, where the judge doesn't poll the jury, as we call it. Can you explain what the judge did there and explain what polling is? And are you a fan of it or not?
As a prosecutor, and I get a conviction, I don't want to poll anybody. I want to get the heck out of there because I don't want this one juror. I had a civil case in Chicago where this one juror got wobbly and I had prevailed. I don't want to poll. But if you're a defense attorney, you don't poll if it's an acquittal, of course. Mm-hmm. That's crazy. But if it's a conviction or even if it's a conviction, you always poll if you're a defense attorney. Always.
The bottom line to me is you never want to poll when you've won, regardless of what side you're on. Case in point, Gene, I watched a friend of mine try a case where they were polling the jury, and the very last juror said, no, I can't go along with conviction. It caused the court to have an up. We're back in for redeliberations. By the end of the day there, it turned out to be a not guilty when it had been 11 for guilty, 1 for not guilty. Who can figure out jury psychology sometimes? Guys, Gene Rossi says, and I don't disagree, the defendant did a great job on the witness stand. We were watching a couple of clips. Let's see if Gene's right. If the defendant continues to go along the path of where he's garnering some sympathy with this jury, with this next clip, we'll be back on the other end. Because I know Aaron Keller is dying to get in that guest chair. Maybe he'll even join me if I'm lucky. Then it will truly be a Law&Crime Christmas.